This is Democracy Watch. I'm joined by my co-host, voting rights attorney and founder of Democracy Docket, Marc Elias. So, Marc, we've got some major and unexpected news out of Mississippi. Can you speak about the recent court decision there and what it did?
This is great news. The Fifth Circuit, a notoriously conservative circuit, just struck down Mississippi's lifetime ban on people voting after they have served their sentences for a whole range of felony convictions. This is a landmark ruling. This is a pro-democracy ruling. It is a pro-voting rights and a pro-criminal justice ruling, and it is something we all need to celebrate.
So how many more people in Mississippi will be able to vote now as a result of this decision?
So we don't have the exact numbers, but the statistics range from tens of thousands to frankly 10% of all Mississippians, which would be over 200,000. So we're talking about a ruling here that is going to sweepingly change the landscape of who is allowed to vote, who, after they serve their sentence, is allowed to regain all the rights of citizenship by being able to cast a ballot.
So I know that we don't have specific numbers in terms of where these reenfranchised people live and whatnot, but do you have any indication of the impact that this could have on Mississippi state legislative elections or even congressional elections? Like, could this actually result in a swing of certain seats?
Well, look, we know that the voters, the folks who are disenfranchised, who will now be voters, were disproportionately Black by large measure. So I would expect that the reenfranchisement of large numbers of disenfranchised individuals who have witnessed the criminal justice system, and many of whom, a disproportionate number, are Black, certainly can change the outcome of elections, as they should. These are folks who live in the community, they pay taxes, and they have a right to participate in their elections.
Now, I presume this will be appealed to the Supreme Court. Do we have any indication as to how the Supreme Court might rule on a case like this?
So they may appeal it to the Supreme Court. They may seek en banc review, which is to ask the full Fifth Circuit to review this. But either way, this was a really, really good job of lawyering. I mean, I have to say the lawsuit that was brought here is different than a lot of the other lawsuits that we've brought involving reenfranchisement. It was brought under the Eighth Amendment, which prohibits cruel and unusual punishment. And what this Fifth Circuit panel said is that a lifetime disenfranchisement as a penalty is in fact unusual. Like, just if you start with cruel and unusual, if you start with the unusual, it is unusual in this country. That is not the trend. That is not where most people are. It's also cruel. It's cruel because it is a penalty that deprives someone who has served their sentence from the ability to engage in civic life. So this case may go to the Supreme Court. Remember, the Supreme Court only hears a fraction of the cases that people ask them to review. They hear between 50 and 60 cases a term, and there are thousands and thousands of cases vying for that. So hopefully the Supreme Court will take a pass on this one.
And just to be clear, if the Supreme Court does take a pass, then that's it. This becomes precedent, and the decision is final.
That's it. You have the Fifth Circuit, you got the Fifth Circuit, and then you got the Supreme Court. The Fifth Circuit has reversed and ordered the trial court to enter judgment.
Now, are there other states with permanent disenfranchisement where this precedent, assuming that it remains precedent, could actually undo that practice?
Look, I think that Mississippi was an outlier in the sense of how extreme their disenfranchisement was. But I think that it's a model. The fact that oftentimes new legal theories start with the most egregious instances, but then they take hold elsewhere. And this is a very intriguing theory because and doctrine that's been adopted here, because the Eighth Amendment jurisprudence talks about evolving sense of decency. And so it counts, the whole notion of something being cruel and unusual is in the times in which you live. And in the times in which we live, there are a lot of states now that are very much outliers in how much they disenfranchise their citizens. And unlike a lot of the other challenges that have not succeeded under the 14th and 15th Amendment, this Eighth Amendment has not been tried many places. So I expect you're going to see more litigation bringing this theory other places, and I expect that it will have success.
Now, are there other cases right now where Eighth Amendment claims are already working their way through the court as a means to undo this type of disenfranchisement? And I understand that Mississippi is an outlier and that there might not be other states with permanent disenfranchisement, but do we have other Eighth Amendment claims?
Look, I think there will be. I think that this is a relatively new ruling, but I would expect in the near future to see similar claims brought in states around the country, and in some circuits that frankly are a lot more favorable than the Fifth Circuit. You know, we talk about the Fifth Circuit being extremely conservative, among the most conservative, Mississippi having among the worst disenfranchisement laws, but there are lots of courts of appeals, thanks to President Biden and his nominees, that are much more pro-voter, are much more pro criminal justice reform, and so I would expect that you will see more lawsuits like this coming.
Right, and it's probably easier to swallow in terms of other more liberal courts seeing that even the Fifth Circuit could manage to recognize like the cruelty in permanent disenfranchisement or some degree of disenfranchisement, then of course other courts with more liberal majorities can have an easier go at that than even the Fifth Circuit did.
That's right, and that's why there's always this strategy of where do you bring these cases? Do you first bring a test case where you've got, the most egregious facts, even though it may be in a very conservative place, with the upside of that if you win there, then as you say, it makes it easier elsewhere? Or do you go with maybe less egregious facts in a place with a more favorable court? And this is one of the reasons why, I always, when people say, yeah, but Mark, you're going to litigate in front of judges appointed by, President Trump or conservative Supreme Court, I always point out, the Alabama case that we all keep talking about, that was decided by a 3-judge panel with 2 appointees by Donald Trump. It was affirmed by the U.S. Supreme Court, a conservative court. And so we can't give up on democracy. We can't give up on the courts. And that's why I started Democracy Docket, to not give up on the courts. And it's why these cases like this one out of Mississippi are so important, because it shows that even a case out of Mississippi in the Fifth Circuit can be successful.
And by the way, just as a quick aside, for anybody who wants to read more about this case in Democracy Docket, the link is right here on this screen. So just hit that link. I'll also put it in the post description. Mark, I know we spoke about in terms of Mississippi's permanent disenfranchisement, but are there other states where there are still practices of disenfranchising voters that are ripe for litigation?
Absolutely. Absolutely. Look, when we talk about, again, I'm excited because this theory, this Eighth Amendment theory prevailed, and it's such a strong one for our times. When we talk about the evolving sense of decency and community, acceptance for punishment, there's really no place left in our country for the disenfranchisement of people who have served their sentences. We saw it in conservative states like Florida, where, there was a ballot measure to re-enfranchise these folks, which passed overwhelmingly. And then you saw Ron DeSantis and the Republicans frustrated. I think that this is going to have wide application in a lot of states where conservative and Republicans have been trying to frustrate the ability of people to get re-enfranchised. So I would look at states like Florida. I'd look at states like Texas, which is also in the Fifth Circuit. And then I'd look at some other states in the Northeast that still have disenfranchisement laws where the courts are certainly more favorable.
And finally, let's finish off with this. Can you speak more broadly about the injustice of taking away somebody's right to vote once they have already served their time?
It is the most profound injustice that one can do is take away someone's right to vote. I mean, the right to vote is the fundamental right that is preservative of all other rights. That's what the U.S. Supreme Court has said. Literally, the right to vote is what gives you the ability to stand up and say, you know what, we ought to amend the state constitution in Ohio. We ought to elect Democrats. We ought to elect Republicans, right? It is the thing that binds you to civic life. And when you take away someone's right to vote, you take away their participation as a citizen in the democratic process. It weakens their ties to the community. It weakens their re-entry into the community, but it takes away something vital about what makes them an American, what makes them a citizen. And so we need to be as committed to the voting rights of people who have served their sentences, we need to be as committed to their voting rights as we are to our own and to our neighbors. And until that fight has been fought and been won, we will not be living in a democracy that lives up to its best hopes and its ideals.
Perfectly put. Marc, thank you to you and your team for the work that you do to protect voting rights across the country. For anybody watching, if you want to help Marc and his team, please sign up for Democracy Docket. Like I mentioned before, it's the free news outlet that Marc founded to keep you up to date on everything voting and elections. The link is right here on the screen. It's also in the post description of this video. I'm Brian Tyler Cohen.
I'm Marc Elias.
This is Democracy Watch.